They've stood at the front lines of law, leadership, and public service. From the courtroom to the classroom, Attorney Karen Jimeno brings sharp legal insight, academic excellence, and a voice that has guided national conversations. Attorney Mike Toledo, a seasoned public affairs strategist and legal mind with years in media, corporate leadership, and government reform. Together, they bring law to life with experience, integrity, and the courage to ask hard questions. Two minds shaped by the law. Two voices trusted in and out of the courtroom. This is ABOGADO.
Good evening and welcome to ABOGADO, where legal minds discuss the toughest issues shaping our country. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, we examine an issue that sits at the crossroads of law, politics, and public accountability.
It's a process meant to uphold the Constitution. But what happens when the process itself becomes the controversy?
The stakes are high, the institutions involved even higher, and the questions we must ask fundamental. Let's take a closer look.
Impeachment. An extraordinary tool to check abuses at the highest levels of government. Under the Constitution, the House accuses, the Senate judges. But what happens when the process itself is in question? In Vice President Sara Duterte's impeachment, the Senate's recent actions sparked legal and constitutional debate. Actions some defend as necessary safeguards, others see as clear overreach. Are these decisions within the bounds of law, or do they stretch the limits of constitutional discretion? As the nation watches a critical test of power, restraint, and accountability, we ask, is the Senate's handling of the impeachment case pushing the boundaries of its constitutional discretion?
Of a lawmaker closely monitoring the Senate's interpretation of constitutional processes is Congresswoman Leila Lima, a veteran lawyer, legislator, and longtime advocate for justice and human rights. She represents mamamayang liberal in the House of Representatives and is set to serve on the panel of prosecutors in the upcoming impeachment trial. A former senator, Justice Secretary, and former Commission on Human Rights chairperson, Congressman Leila has long championed public accountability, legal reform, and the rule of law.
Now, offering insight from within the Senate's communications front is Attorney Regie Tongol, lawyer, media personality, and strategic communicator. He currently serves as the official spokesperson of the Senate Impeachment Court. Attorney Regie is the managing partner of Regie Tongol and Associates Law and Communications with expertise in libel, entertainment law, and crisis communication. He is also a former news anchor and assistant secretary for strategic communications under the Aquino administration.
I'm especially excited about tonight, partner. We have very impressive people with us today.
No doubt.
But before we begin the exchange, let's take a look at how tonight's discussion will unfold.
We begin with the opening statements. First, the speaker supporting the proposition presents their position in a focused 2-minute statement. Then, the speaker challenging the proposition offers their perspective, also within 2 minutes. The conversation then unfolds through two key subtopics. For each subtopic, the guest supporting the proposition presents their insights for 2 minutes, followed by a 2-minute perspective from the guest challenging the proposition. After both perspectives have been presented, we move into the open exchange. A 6-minute free-flowing discussion where both guests ask questions, share points, and respond to each other directly. Once both subtopics have been explored, we proceed to closing reflections where each guest is given 2 minutes to summarize their key messages. And finally, the hosts step in with their own questions. In this 6-minute segment, the guests respond, clarify, and deepen the discussion, ensuring no critical point is left unexplored.
And now let's begin. The question is, the Senate's handling of the impeachment case pushing the boundaries of its constitutional discretion? Senator De Lima, your opening statement, please.
Oh, yes. Answering that question, it is a definite yes for me. I do believe that the Constitution does, in fact, set limitations to the discretion, to the powers, to any act on the part of the Senate. It's very clear because the Constitution says that the House has the exclusive power to initiate, and it did that already. The House job was concluded. Now it's the Senate's turn. And what is the job? What are the specific instructions of the Constitution to the Senate? To me, it's only three. To convene as impeachment court, they did already, but they have again to yet reconvene and imposing all those requirements for purposes of reconvening. The second instruction is to hold impeachment trial, to receive evidence, to look at the evidence, to evaluate the evidence. And the third instruction is to render a verdict of either acquittal or conviction. No other verdict, so to speak, can be rendered by the Senate as an impeachment court. In other words, to me, reading both the Constitution and the very rules of impeachment adopted by the Senate, what we have is that 2011, with the resolution number 39, that was during the time of Senate President Enrile, which was adopted for the trial of former CJ Corona. There's nothing there about dismissal of the case at the first instance or even before the holding of impeachment trial, both in the Constitution and the rules of the Senate. So where is that coming from? So every time that the Senate or some members of the Senate come up with certain invented procedures or invented technicalities, which to me, serve as barriers for the immediate holding of an impeachment trial. And the immediate is very clear. The word forthwith is very clear. So this is being violative of the Constitution. So far, the steps and the moves taken by the Senate, especially the pronouncements of the Senate President, are, to me, violations of the Constitution.
Thank you so much, Congressman Leila. Now let's turn to Attorney Regie, your opening statement.
The actions of the court is actually sanctioned by the Constitution. The express power to solely try and decide a case is given by Article 13, Section 3, number 6 of the provision of the Constitution. However, we always forget that for any court, based on the case of Defensor Santiago versus Vasquez, there are also inherent powers. It's not only the implied or express powers that is given to a court, there are inherent powers. And one of the inherent powers of the court under the case of Bilag versus II is to first determine whether or not it has jurisdiction over the subject matter presented before it. And that is what the impeachment court, in its textually demonstrable commitment to exercise its sole power to try and decide, has done. It has interpreted its power to try and decide and actually exercise its inherent power to determine the sufficiency of the articles of impeachment. The only limitations set by the Constitution are under Section 3 of the same Article 11, which is Section number 6, 7, and 8. First is that the vote should be 2/3. Second is the penalty cannot extend beyond removal and the disqualification, perpetual disqualification from holding office. And the last one is a self-imposed limitation or regulation so as to give the Supreme Court, with the judicial power, to actually have a manageable standard to see if there is a grave abuse of discretion, which is the promulgation or to adopt the rules for the exercise of its power to try and decide. So on that matter, there is the power of the impeachment court to see that whatever it is trying in front of it has basis in law.
Okay. Very well articulated opening statements. Let's turn to our first subtopic, which would be the procedural boundaries and constitutional compliance. Are the Senate's actions such as remanding the articles of impeachment, requesting further certification from the House, and entertaining motions to dismiss, aligned with its constitutional mandate.
Now, Senator De Lima, you have 2 minutes.
Okay, consistent again with my answer to the court question, to the first question, my answer would be a categorical no. There's no power to remand, whether it is express or implied, because any discussion about implicit powers, implied powers, should always flow or should always come from within the parameters of the Constitution. And the parameters of the Constitution are very clear. Initiation by the House, and when it did adopt the resolution and transmitted the articles of impeachment, that means, you know, that they are convinced about the legitimacy, the basis of the charges, the 7 articles. And so the next step, and again, that's a very boundary or limit set forth in the Constitution, is to try and decide. For me, there is no other discretion but to try and decide. Even in the rules, I've been reading and rereading the rules of impeachment of the Senate as adopted by the Senate. And even if they did mention, one of the rules there mentioned motions, but the rest of the paragraph would pertain to motions pertaining to procedural questions and also to admissibility of evidence, for example. So preliminary questions like that, evidentiary questions like that, questions on admissibility, relevance of evidence, then it can be subject to proper motions, but not the dismissal of the case before the holding of the trial. I see no discretion, no option being made available to the Senate as an impeachment court for such a thing, dismissal prior to trial.
Well, Attorney Regie, your response to that?
Well, there are 2 ways to go about it. First is being textualist in the Constitution, and another is being pragmatist. So the textual constitutionalists will often argue the very specific details or the text of the Constitution. However, they fail to consider that not everything is within or provided by the Constitution. There are things such as presidential immunity or privileged presidential communication that has not been provided specifically or expressly by the Constitution. However, the President or the executive branch has also the power to interpret the Constitution under the case of Manila Prince Hotel versus GSIS. And the same way, in exercising its duty, the Congress, whether it's the House or the Senate, has also the power to interpret the Constitution at what it entails to try. And as I said earlier, there is an inherent power of the court to actually decide or figure out how it can proceed with trying the case. And one of the things that has been, we are now going to the pragmatist side. Now, what has happened in the June 10 deliberations, there has been a motion to dismiss. And what the court has decided to do is not to dismiss the case, but actually to help the case out, to continue in exercising its trying. Because there is a certain issue that was raised by one senator judge, which under the Senate rules cannot just be brushed aside without first having a vote or a motion on it. So to prevent any embarrassment to the senator judges and to the Senate as well, there has been a motion that to amend that said dismissal. And that is the action of the court, why it just decided to just ask the House to help us answer these issues that was raised before us.
Well, thank you so much, Attorney Tongol, for that explanation. And now, this is the part that my partner and I really enjoy this. We now open the floor for robust exchange. You may raise questions, clarify points, or offer additional insights. So, attorneys, you have 6 minutes. Who would like to begin?
Ladies first, ma'am.
Okay, I will be harping through the end of this program. I will be harping on that. Where in the Constitution does it say that that dismissal is allowed? And then the very fact that you just explained a little earlier, that, okay, they categorically said when they opted to just remand or return, whatever that is they categorically say that they are not dismissing or terminating the proceedings because they cannot do so because the articles of impeachment have been transmitted to them. So the only thing left now here is to attend to the trial. And all questions pertaining to the trial, as I said, admissibility of evidence, di ba ganun yun? Yung dun talaga sila magfo-focus? Kasi yes, you've been saying about the implied powers, but the implied powers must necessarily come from the express powers. The express powers is just to try and decide and not to dismiss. Not even in the verdict itself. That's why the verdict is limited to acquittal or conviction. So yung mga motion na yan, pwede yan sa mga preliminary matters and evidentiary. So don't you think that is the very, that's why may step-by-step procedure na linagay ang Constitution, sa Constitution. And the step-by-step procedure, again, is initiation, transmittal of the articles of impeachment, and then the trial and verdict. Those are the step-by-step procedure because, of course, the framers of the Constitution knows that this is a politically charged process. The impeachment is definitely a politically charged impeachment. So they're aware of that. So they have to set guidelines in order to obviate arbitrary actions on the part of both the House and the Senate. And I do believe that in so doing those things, not immediately commencing the trial, under the guise of it's an electoral break, that was transmitted way back in February 5. And then that is definitely what the word forthwith means. And then uli, ito na naman, na merong nagmosyon, si Senator Bato, the de facto dismissal, and then as a sort of an amendment, this remand or return, which is actually very questionable and improper because it means they are disrespecting the institution, the House of Representatives. There's supposed to be presumption of regularity. Tinasmit na sa kanila yung AOI. So bakit kailangan pang ipa-certify na that was consistent with the Constitution, walang bina-violate sa Constitution, and whether the 20th Congress would still be pursuing. Those are improper requirements and not sanctioned by the Constitution. So I always go back to that. Kaya nga may ganyan, mga limitasyon. Kasi nga, they can do or exercise arbitrariness.
So I guess, Attorney Regie, how do you respond to that? That was really a series of strong arguments, which in effect says that Congress did what they did under the Constitution, and Senate, under the Constitution, has no other task but to forthwith proceed with the trial. So how do you respond to what the senator said?
That is the view of one lawyer. However, there is no jurisprudence regarding that matter because this is a case of first impression. So the Senate itself is still navigating this issue. There is still an ambiguity on what it entails to try and decide. The previous cases of Estrada versus Desierto, of Francisco and the Gutierrez cases did not actually dwell on it. Now, as to the forthwith, let me just cite the 3 cases decided by the Supreme Court which the other parties did not at all mention. They always say forthwith, this immediate, etc. However, as we know in law, there is no need for construction or interpretation if there is already jurisprudence about the matter. And there is the Fisher versus Ambler decided by the Supreme Court of the Philippines, Meyer and Company versus Antos, and New Masonic Temple versus Alfonso. Those 3 cases already said forthwith is not immediately. Forthwith should take into account the situation if there is a reasonable or unreasonable delay. In this matter, there is no unreasonable delay. There is no remand. there is no articles of impeachment that was returned back to the Senate. It was referred back to the Senate for completion of some jurisdictional requirements for the certifications. So there, if you read the order, there is a collatilla there that this does not dismiss the case. This does not terminate the proceedings. So that alone is actually just an dialogue with the House of Representatives na as the legislative branch of government that is involved in this impeachment process, help us out to already make this political question for the Supreme Court not to anymore interfere to avoid a political or a constitutional crisis. So that was the duty that was done by the majority of the Senate Impeachment Court.
Well, I have a question to both of you, and I think this also is something that Congressman Leila, you can share your thoughts on. How limiting is the wording in the Constitution? Retired Justice Ascuna, who's one of the drafters of Article 11 of the Constitution, said that it is not unconstitutional to remand the articles of impeachment back to the House. But when we say that the Senate, as an impeachment court, has the duty to try the impeachment case, is that similar to the courts, where when they proceed to try something that's filed with them, they do decide on procedural infirmities as well? Is that something that is implied? And do we have to limit ourselves to the wording in the Constitution when the rules of court suppletorily apply to an impeachment trial?
Yes, there's supposed to be supplementary application of the rules of court, but there shouldn't be any liberal application of that principle, of the supplementary application of the rules. And in fact, again, in the Senate impeachment rules, that portion on that the rules of court will be, as far as practicable, will be of supplementary application, is part of a rule that governs actually the motions, again, with respect to evidentiary matters and technical matters, and not about dismissal. So,
But it's not a dismissal here, right? If you just remand.
there's no dismissal yet.
Yes.
Yes,
But,
and I think there was a colotilla that this is not considered a
Yes,
dismissal.
there is a colotilla,
Yeah.
but there has been statements from certain members of the Senate, including the Senate President, that nothing would prevent them from resolving the motion to dismiss, when in the first place, they shouldn't be entertaining any such motion to dismiss.
What's going to happen if the Supreme Court decides this issue on infirmities that the Senate raised? For example, the one-year bar rule, which is pending in the Supreme Court.
Without the certifications to be issued by the House, the two certifications, it will be a factual battle with the petitioner in the Supreme Court. So, but with the certifications issued by the House of Representatives, it will preclude and it will give both Congress, the Senate and the House, a defense and an excuse to say, hey, Supreme Court, you cannot decide on this. We have decided as a legislative body, and this is already a political question. You cannot stop us anymore from continuing on with the case. That is what we kept on explaining to the people, that this is not a delay that was just unreasonable delay that has no reason at all. It is actually to preclude, to foreclose, and to forestall the arguments for the dismissal of the case.
But
So,
is that
because
correct?
I didn't want to.
Congressman, because
I still
a
maintain.
certification will bind the Supreme Court. Is that legally correct?
I'm not sure about that. I don't think they can say that. Now, the issue about the violation, the alleged violation of the one-year bar rule is precisely before the Supreme Court already. Now, why would now the Senate as an impeachment court be dwelling on that issue when that's actually really out of their concern right now? Because the mandate, again, the directive of the Constitution, express directive, is to try and render the verdict. Now, if the Supreme Court later would decide, no, wait a minute, because it violates the
One-year bar rule,
one-year
yeah.
bar rule. Can anyone dispute that?
Ano, partner? Yeah, that's the
It's a
thing. no?
constitutional
Yeah.
issue.
And that
already-
actually
now that we
deprives
touch-
the respondent here of
Exactly.
due process as well.
Exactly.
Because she's seeking remedy in the Supreme
Correct.
Court.
But-
But if they take the certification
Yes,
of Congress
yes.
as the final say, then
That-
the
that-
respondent
yes,
is deprived of that
yes.
remedy.
That is why I would like to ask also both of you, because you already raised the topic of the 1-year impeachment that shall be filed, just one impeachment within a period of 1 year. But one of the questions that are really being asked is, when is it considered filed?
Yeah.
There seems to be arguments as to when it is actually considered filed. Some would say that it is already filed when a verified complaint is received by Congress and referred already to the committee that should be
Committee on
hearing it.
Justice, yeah.
In this case, the Committee of Justice. Others argue otherwise. No? So, one, that's my first question to the both of you. And number two, and maybe this a bit looking forward, tignan din natin, no? Kasi, di ba, ang sinasabi ng ating mga senador, baka daw sila mag-file ng motion to dismiss. Pero may argument na sabi, wala kayong karapatan na mag-file ng motion to dismiss kasi hindi naman yan one of the things that you can do. But it's an argument as well na pwede daw. Now, let's assume for the sake of argument na nagkaroon na ng hearing at nag-file ng motion to dismiss. Nandun na, dinismiss. Pwede iakyat sa Supreme Court yan.
Yes. Yes.
So, on those 2 points,
Well, about the when is an impeachment case deemed initiated?
Yes.
There's been cases already, including the Francisco case. It's
And
not
even
the
the
mere
Vidi
filing,
case.
correct?
Yeah.
It's not the mere filing of the complaint that would be the step to initiate. Is the if the complaint was filed under the 2 modes, that is, by a member of the House or by a citizen and endorsed by a member of the House, then the mere filing is not initiation. Initiation comes in when it is referred to the proper committee, the Justice Committee. Now, for the 3rd mode, which was the very mode adopted in this case, and just like the previous cases of impeachment, direct resolution by the House by a vote of at least 1/3. So that is the initiation, the filing, and the verification of the complaint and transmission or transmittal to the Senate. That is what that is considered initiated. But the mere filing itself, di ba dito may tatlong impeachment complaints by various groups, but they were not acted upon until the 10th day, the 10th session day, which is really the deadline. You know, so walang rule na pag meron ka agad na impeachment complaint final, automatic na dapat i-refer ka agad.
So walang forthwith when it comes to Congress.
When it comes to it's just a 10 session days to wait before
And
it can be acted upon.
didn't they consolidate?
Was it a consolidated version or a
wasn't there a
separate
consolidation version?
version?
Because there were about 4.
I don't know, I can speak for the House.
Yeah, that's true. Oo.
Yeah.
Well, I guess
The consolidation is the House version, the verified complaint itself by at least 1/3, by about 215 plus members of House of Representatives, a lot more than the required 1/3. That you can call that a consolidation. It's not strictly consolidation, but they did not touch anymore the first 3 complaints. And this one is a separate mode. So there is no question here about the proper initiation of the impeachment by virtue of that verified complaint by the members themselves of the House of Representatives.
However, we have to
Yes.
remember that in the adser ad coetelam, there was an issue raised on the jurisdiction,
Yes.
reiterating again what the Vice President said in the petition for prohibition in certiorari.
Which was pending in the Supreme
Correct,
Court.
which is
yes.
pending in the Supreme Court. So, given that scenario, how will the senator judges decide on it? Will they table it? Will they actually decide it? Try first the merits and then decide on it before actually deciding on the ultimate question to convict or to acquit. So we don't know yet because it's still in the future. So that is the precarious situation, and I think that's where the Senate President as the presiding officer is coming from. That once it is there already on the impeachment court table because it was raised, then it cannot be just brushed aside. it has to be tackled whether they will decide on it or not is up to the majority of the impeachment court. Now, as to the certification, let us not forget that there are two certifications that's required. The first one is for the 1-year ban, and the House of Representatives has already complied with it, submitted their compliance. As to the second certification, it is a case of first impression. This is the first time that an impeachment will traverse from one Congress to the other. So that's why the court said, hey, House, can you please confirm and reaffirm whatever you did in the 19th Congress is the same thing that you're going to do and prosecute in the 20th Congress. So it's just a dialogue with the 20th.
Yeah. So
but can it be argued, partner, but can it be argued that the crossing, no, but the fact that in the 19th Congress, they already actually presented or submitted to the Senate the articles of impeachment, and that should hold because can that be argued? Because the Senate Impeachment Court is different from a Senate acting as a legislative body. Therefore, legislative calendar takes a back seat when the Senate Impeachment Court is convened. So, can it be argued na hindi hindi na kailangan na hingin pa ng certification ng 20th Congress dahil sinabit na nga ang articles of impeachment ng 19th Congress.
We don't know yet if that's necessary. However, the impeachment court wants to be assured and secure. So, because there are two schools of thought about it. For one, the impeachment court never lost jurisdiction based on the principle of adherence jurisdiction. Once it acquires jurisdiction, it cannot use it. However, the House prosecutors lost their authority because their term ended from the 19th to 20th
They're not
Congress.
a continuing body,
So
not
as
like
of
Senate,
now,
right?
we don't have a set of House prosecutors. As Secretary or Congresswoman De Lima will be and assumed to be partly one of the prosecutors, she hasn't been given her authorities yet. And it's only the formal action of the College of the Congress that can give that authorization. And since there's already going to be such process, the impeachment court is just asking, sabay nyo na lang yan. Isabay nyo na lang kasi mag-a-appoint rin naman kayo ng bagong prosecutors.
But Cong,
I still maintain that the second requirement is really improper and unnecessary because the premise there is that there can be no crossover. They're not sure whether the next Congress, the 20th Congress, would be taking off from what was done in the 19th Congress. So that is the very premise. And that premise for me is fallacious because our basic argument here is that the Senate is a continuing body. And especially insofar as non-legislative functions are concerned. These are not deemed terminated or it does not expire simply because there has been a new elections held. And that's why and simply because the composition, for example, of the Senate is somewhat modified. Hindi na exactly the same. So, in requiring those two certifications, para sa amin, ang premise ng Senate by doing that is they are really not adopting the position that impeachment initiated under the 19th Congress can cross over to 20th Congress. That's why it's unnecessary, it's improper, and it's also it's a disrespect actually to the other house.
So, Congressman Leila, do we take it that Congress has not provided that ratification yet? And would you say that from a practical perspective, if you were to comply with this requirement of the Senate Impeachment Court, you'd have to gather signatures again from all members of the House of Representatives to ratify? But before you answer that question, let's take a quick break. Up next, we'll have our final reflections from our guests as they make their closing arguments. Stay with us. This is Abogado.
Bilis naman.
Welcome back. You're watching Abogado. Our question tonight is the Senate's handling of the impeachment case pushing the boundaries of its constitutional discretion. We've heard two thoughtful perspectives from Senator Leila Lima, representing Mamamayang Liberal in the House of Representatives, and of course, Attorney Regie Tongol, spokesperson of the Senate Impeachment Court. By the way, partner, before we go to the closing reflections, I just wanted
we'll
to
pick up from my question.
pick up from your
with
question, but I just want to make a
Leila.
comment that the three of us somehow were involved in
Impeachment,
impeachments.
yeah.
You were the
nga, no?
spokesman during the Chief Justice Corona's impeachment. I was the spokesman during President Estrada's impeachment, and you are now the spokesman for this for the Senate in this
Court.
impeachment court.
And
So-
we have a prosecutor
And
here.
a prosecutor.
And then I was a witness in the Corona.
Oh,
Exactly.
no,
So,
pero
I was
kompleto
present
pala
there.
tayo. Mga mga meron lahat
Yes.
experience sa impeachment. So, how wonderful to have everyone their thoughts
Exactly.
here. But really, kung alam lang nila kahit nung commercial break, lahat tayo nag-uusap, no?
Yes.
Kasi it's really an interesting topic
Yes,
for
it
lawyers
is. It
especially.
is.
So, Congressman Leila, what are the thoughts of the House of Representatives in terms of complying with that requirement to ratify the articles of impeachment by the 20th Congress? Kasi actually may in-interview ko sa At the Forefront na isang member of the House of Representatives na neophyte. Pero sabi niya nga, how will that work? Nag-aantay daw siya kung may iikot sa kanila na for signature, whether they're in favor of ratifying the impeachment. Pero so far, wala pa nga daw. But operationally, napag-usapan niyo na ba sa House how that will be complied with?
Okay, let me clarify that I'm not yet an official member of the prosecution panel, although I have assumed office already as a member of the House of Representatives. So we are not really privy yet to any discussion by the House leadership or even by the prosecution panel. So every time I'm interviewed and I guest in programs like this, I would always say, this is my personal opinion. Now, the way I read it, if in some mga news items and certain pronouncements also, di ba they deferred the compliance in respect to the first requirement, and especially with the second requirement. Because at that time, as of that time, hindi pa sila pwede mag-certify because 19th Congress. So it's the 20th Congress. So even, I think there's what I can sense is that the House of Representatives, especially the prosecution panel, is that they're being cautious about this. That, okay, they're caught now between, can we comply or not? Do we need to comply? What is the consequence, the implication? Kasi nga, the position always is that we've done our job, we initiated already by that verified complaint and by transmitting. So what is left to us on our part is yung prosecution by the designated panel of prosecution. So if we keep on obliging the Senate and complying what they order us, then we are actually saying that would be self-contradictory dun sa position na tapos na kami dyan eh. Ano pa bang hinihingi nyo? Isn't that enough? Isn't the articles of impeachment already the very certification that it is compliant with all the constitutional requirements? So yun ang sense ko. Hindi nila alam, maybe they also want, out of respect, out of courtesy, but they want to make sure that there is also they won't be stopped from raising certain issues about the propriety, the very propriety and validity of the actions of the Senate.
Kami naman as lawyers, alam naman natin, bakit hindi na lang mag-issue ng certification? So, napakadali naman. Sabi ni Congresswoman, ayaw nilang maging stopped sila. Eh, di lagyan lang ng kolatilya doon na parang this does not waive any whatever, the defense or whatever remedies
that they
afford
have.
to us. I mean, yun lang naman yun. But how does Congress comply? How does
The
a collegial-
ratification specifically.
Correct. How do they comply? In a collegial body like that, it's only through an action by the plenary. So whether it's adoption of a resolution that was passed or in the plenary, there is already a votation that's happened by the yeas and nays, then that's going to be acceptable for the compliance on the second requirement.
So, Attorney Regie,
so I think
if-
that's easily can be done.
Yeah. So, Attorney Regie, if with the new composition of the 20th Congress, they don't get an approval at the plenary level of that ratification, what would the Senate do then? Will they still proceed with the trial, or will they say that there was non-compliance and therefore they cannot proceed with the trial?
I don't know because that's in the future. I cannot hazard a guess. Anything is possible as of the meantime. However, to preclude and to just focus on what can happen actually is if there is a certification, we already know that the House prosecutors can already say to the impeachment court, hey, we already complied. So don't dismiss us anymore. So once the defense will go to the Supreme Court, as of now, there is an impending case still that might halt the proceedings with the impeachment court. We can say, both Congress and the House say, hey, this is already a political question. Don't decide on this anymore.
Attorney Regie, don't you think that if the Senate or the senator judges would move for a motion to dismiss, as a lawyer, can't you also argue, di ba dapat ang nag-move ng motion to dismiss ang defendant, di ba? Di ba hindi ang judges? Bakit ang judges, can you imagine in court, di ba? Ang judge mismo nagsasabi, I move to dismiss this case. Isn't it the option or the prerogative of the defendant to move for the dismissal of a case?
However, we forget that in ordinary courts, once a complaint is filed, the judge can already decide to motu proprio dismiss it based on Rule 9, Section 1 of the Rules of Court. So, because of that, we just saw it, that if ever that was the thing that happened in June 10, we just saw the deliberation of one of the senator judges. And in a collegial body such as the Senate or the Supreme Court, one justice or another will do the devil's advocating there and actually question if there is sufficiency in the complaint.
May I respond to that?
Yes,
May I respond to that?
Congresswoman Leila.
This is not an ordinary case. This is impeachment. And impeachment, the instructions again of the Constitution are specific. Even the suppletory application of the rules of court should be sparing and should also be, it has to do with the trial itself. The suppletory application of the rules of court must pertain to evidentiary technical matters, but not on the very issue of dismissal. That cannot be entertained at all, dismissal. So kung yun ang premise, yun ang balak ng Senate para sigurado tayo dyan sa mga question na yan, para tuloy-tuloy na tayo sa trial natin. No, because that means they are still entertaining the very idea of dismissal, which cannot be done, whether by a senator member, a senator judge, or by the defense. Dismissal at this stage before trial is not at all contemplated by the Constitution insofar as impeachment cases are concerned. So it really begs the question, if you start explaining that, justifying, kasi nga para hindi na siya maging dismissible later, that means there is still the idea, you're still entertaining the idea of dismissal when it's not there in the Constitution, the very spirit of the Constitution.
Well, I'll throw in another question. Is the doctrine of prejudicial question applicable to an impeachment case? In the same way that there is a question of a procedural or an infirmity, supposedly, if there's a violation of the one-year bar rule, will that serve to be considered a prejudicial question that would prevent the impeachment court from trying the case?
In the first place, again, okay, the very fact that the articles of impeachment has been transmitted to the Senate, that is already proof that the House of Representatives has complied with the rule. Insofar as they are concerned, they have complied with the rules. And they have the rules of impeachment also. Wala akong nakita doon any violation by the House of Representatives, unlike on the part of the Senate. Because I've been rereading, actually, the rules of impeachment of the Senate. And there's nothing there about dismissal. The motions there pertain to technicalities and evidentiary matters, but not the very issue of continuing or dismissing it before trial.
I think that is what happened. That's why the impeachment court did not dismiss it, because they don't know yet what to do. with the issues that was raised by the Senator Judge De La Rosa. That's why Senator Cayetano just said, hey, maybe we can just ask the House to just certify these matters. So, I mean, that is the political side of it, because this is a sui generis case. It is not merely legal, but the political side of it is that it is a collegial body. They have to like talk amongst each other. How do we navigate this issue? And that is how the impeachment court, by the majority vote, exercised its wisdom by just referring it back to the House and, hey, let's dialogue about it and let's settle it amongst ourselves.
Very interesting. Bitin! Even Senator Leila was saying earlier ng commercial, ang bilis naman ng time. But
I guess, partner, those were part already of the closing reflection.
Yes.
So,
Yes.
any final words,
Any final word?
Senator Leila? Nandito talaga tayo,
Okay.
Congresswoman Leila. We're still used to calling you
A
Senator.
very clear parallel issue here is about the confidence of the public, the trust of the public in the whole proceedings. So, how do we ensure that the faith, the confidence of the public, the trust of the public is maintained? There's only one answer. Follow the Constitution.
Attorney?
The confidence of the public in the impeachment court process cannot be undermined by especially the litigants. So we have to have faith in the rule of law, because what if it happens that the impeachment court will now favor the person who is actually chipping away at the credibility of the court? What will happen? The public will not think of it as a fair decision. So that is what the impeachment court is trying to do, to balance everything out, to avoid a constitutional crisis. Because the try and decide doesn't have any demonstrable or measurable standard that the Supreme Court can actually decide on. So it is making up its own interpretation because of the fact it has the power to do so under Nixon versus U.S. as stated in Estrada versus Desierto.
Thank you. Partner, what resonated?
Well,
in
for
this
me, what
discussion tonight?
resonated was really the various views. So I agree with Congresswoman Leila that just follow the Constitution. But what is happening right now is that different people have different interpretations of the Constitution. So parang yung sinasabi nila, sometimes kung gaano karaming lawyers, ganun din kadami yung legal views.
Same thing with economists, by the way. Ako naman, partner, what resonated with me is the fact that after hearing all the discussions, very erudite discussions, no? At the end of the day, ang impeachment is really a political process. At ang pumasok sa isip ko talaga, yung nangyari sa dati kong sinisilbihan na presidente, kay President Erap. Alam niyo po, alam naman natin noon, this impeachment, you had really more than 1/3 filing the articles of impeachment. During Erap's time, it was much less. In fact, it was much less. But when it was brought up to the plenary, the then speaker, before anything could have been done, before everybody could object, talagang nag-shortcut at pinadala na sa Senado. The reason I'm saying that is ganun talaga ang nangyayari pag impeachment. Kasi political. Nandun na nga yung batas, nandun na, klaro na yung ating saligang batas, pero somehow, nagagawa ng kung ano-anong paraan para either madelay or mapabilis. Yun lang ang...
Well, that's why I think discussions like this is very important to enlighten the public so they also know sinusunod po yung proseso, tinatagalan ba or hindi. So, thank you so much, Congresswoman Leila de Lima and Attorney Regie Tongol for sharing their insights in tonight's important discussion.
Yes, in times of uncertainty, reasoned discourse is more essential than ever, and you witness it tonight. What happens in the halls of power must remain grounded in principle and law.
That's the promise of Abogado, to question with respect, debate with rigor, and always seek the truth behind the argument. This is Abogado. Good night.